I'm placing middle paragraph, second paragraph of impugned order. It is submitted by Royal Council for the petitioners that case was registered under section 147, 148, 149, 341, 323, 324, 307, 506, 504 of IPC against all equipped persons, and police has submitted charge sheet only against these petitioners. FIR was against 11 persons and police has submitted charge sheet against 7 persons, exonerated allegation against 4 persons. And order taking accordingly.
And there are 7 petitioners.
There are 7 petitioners. And accordingly, cognizance has been taken in charge sheeted sections and case was committed to this court. It is further submitted that the case was fixed for framing of charge. It is further submitted from procedure of injury report. It transpired that all injuries were caused by hard and blunt substance and simple except injury to Sarwan Kumar Giri. One injury has been shown grievous, which is not vital because ये हमारा डिस्चार्ज पिटिशन में पैराग्राफ 6 में हम लोगों ने लिखा है कि दैट वाज ऑन द पार्ट ऑफ हैंड. इम्प्यूग्ड ऑर्डर में कहीं नहीं आया था कि कहाँ है इंजरी, इसलिए हम इसको बीच में पेज 36 का पैराग्राफ 3 में हम लोगों ने लिया.
Please continue.
Yes, it is further submitted that section 326 and 307 of IPC are not applicable in this case, hence fit to be discharged in these sections. It is further submitted that injury of one Ram Nihora Giri is shown previous in over the side of parietal bone, but Ram Nihora Giri has not been examined by the police eye. It is further submitted from collegial of FIR and entire case diary. It appears that there is land dispute in between the informant and others and petitioners, and that there is case and counter case pending before both the parties. It is further submitted that allegation against the lady members therein that they have sprayed chili powder only under section 326 and 307 of IPC is not attracted at all. This is our submission. Page 21 may kindly be permitted to be placed FIR. दिनांक 7/8/2021 को करीब 11 बजे से 11:30 बजे घटना का वर्णन इस प्रकार है. मैं अपने 2 भाई साथ में खेत में काम कर रहा था. मेरे भाई का नाम वीरेंद्र गिरी उम्र सो एंड सो, उपेंद्र गिरी उम्र सो एंड सो, पिता सो एंड सो. हम तीनों भाई अपने खेत में धान रोपने के लिए खेत बनाने का कार्य कर रहे थे. इस जमीन का खाता प्लॉट नंबर सो एंड सो. उसी समय दिनेश्वर गिरी अपने पूरे परिवार एवं सदस्यों एवं भतीजा वशिष्ठ गिरी पिता सो एंड सो के ट्रैक्टर के साथ आए और माँ बहन को गाली करते हुए कहने लगे कि ये खेत हमारा है, तुम लोग इस खेत से हट जाओ नहीं तो जान से मार देंगे. इतना कहकर दिनेश्वर गिरी सीधे गड़ासा से वीरेंद्र गिरी के ऊपर, ये सिंपल इंजरी है इसके वीरेंद्र गिरी के ऊपर, जानलेवा हमला किया जिससे वीरेंद्र गिरी का माथा फट गया और पूरे शरीर में कई जगह चोट है. राम प्रवेश गिरी, संजय गिरी, श्रवण गिरी के ऊपर बलुआ से वार किया जिसमें कई जगह गंभीर चोट आई है. कामाख्या गिरी ने लोहे के रड से तीनों भाई के ऊपर जानलेवा हमला किया. इसी बीच बवाल के बगल के दोहर में राम निहोरा गिरी उम्र सो एंड सो अपने खेत में रोपनी के लिए खेत बनाने का काम कर रहे थे. तभी वो हल्ला सुनकर दौड़े आए और बीच बचाव करने लगे. इसी बीच दिनेश्वर गिरी अपने तीनों पुत्र एवं भतीजा का नाम सो एंड सो लोगों से मिलकर राम निहोरा गिरी के ऊपर जानलेवा हमला गड़ासा रड एवं बलुआ टांगी से वार कर दिया जिसमें उसका माथा फट गया और गंभीर चोट आई. साथ में सजनी देवी एक्यूज नंबर 5 अभी चार्जशीट प्लेस करेंगे लॉर्डशिप. ये इसके अगेंस्ट फाइनल फॉर्म आ गया है. पति सो एंड सो ममता देवी एक्यूज नंबर 4, इसके अगेंस्ट पेज 33 में फाइनल फॉर्म आ गया है. बबीता देवी एक्यूज नंबर 6, इनके अगेंस्ट भी फाइनल सबमिट हो गया है। ब्लू देवी एक्यूज नंबर 7, इनके अगेंस्ट भी आ गया है फाइनल। इन सभी के हाथ में हसुआ, कुदाल, टांगी, पत्थर और मिर्च का पाउडर भी था, जिससे चेहरा पर छिड़क दिया और सभी महिला पुरुष कह रहे थे कि ओझा और डायन का काम करते हो, सभी लोग को भूसा खाद भरवा देंगे। इज्जत चाहते हो तो जमीन हम लोगों के नाम से लिखकर इस जमीन से भाग जाओ, नहीं तो उसके बाद का अंजाम भुगतने के लिए तैयार हो। Thereafter, I'm placing page 28 is the FIR, first FIR lodged by us, Desligan 64. This is the first FIR. निवेदन पूर्वक कहना है कि मैं दिनेश गिरी, पेटिशनर नंबर 1, पलामू का निवासी हूँ। दिनांक 7/8/2021 को समय करीब 9:30 बजे सुबह में मेरा लड़का
आपका डिस्चार्ज का पिटिशन
हाँ।
है, तो डिस्चार्ज के विद इन पैरामीटर्स में ही प्लेस करें, ठीक है ना?
ठीक
वॉशिंग नहीं चल रहा है ये, या आप बताएंगे कि केस एंड काउंटर केस है तो आपका डिस्चार्ज हो जाना चाहिए, ऐसा कोई लॉ है क्या? केस एंड काउंटर केस होने से डिस्चार्ज, केस एंड काउंटर केस होने से इंसिडेंट प्रूव हो जाता है, ठीक है ना?
ये पेज 33 इंसिडेंट इज पार्टली प्रूव्ड पार्टली डिसप्रूव्ड, बीच में अपीयर फ्रॉम पेज 30। हाँ, ये क्रिमिनल केस में इट इज रिक्वायर्ड टू बी प्रूव्ड इन टोटो व्हाटएवर
डिस्चार्ज के स्टेज में भी
नहीं। डिस्चार्ज के लिए हम प्राइमा फेसाई बता रहे हैं कि 307 नहीं बनता है, बस यही
307 बनता है। आपको एक चीज बता दें
जी,
गोली मारेंगे इंजरी नहीं होगा, 307 बनेगा कि नहीं बनेगा?
अगर हिट करेगा और
अगर हिट नहीं करेगा तो भी 307 बनेगा कि नहीं बनेगा?
मेरे विचार में तो नहीं बनेगा।
आप कौन सा विचार, लॉयर की तरह विचार व्यक्त करिए।
मैं लॉयर के तरह ही विचार व्यक्त कर रहे हैं।
प्रोसिक्यूशन साइड से तो आप अपीयर होते थे, ऐसे ही बहस करते थे क्या कि गोली मारे और गोली नहीं लगा तो 307 नहीं बना? यस
अभी सिर्फ हमको अपना केस प्लेस करना
नहीं,
है।
वही नहीं, आपको अपना केस बहस करना है, लेकिन लॉ के दायरे में रहकर।
लॉ के दायरे में ही रखना।
ऐसा सबमिशन ना करवाइए,
नहीं, वैसा
ना लिखवाइए।
वैसा कोई सबमिशन मेरा नहीं रहेगा व्हिच इज बियॉन्ड लॉ पॉइंट्स।
देखिए, आई टेल यू वन थिंग,
लॉर्ड्स,
द इंसिडेंट इज प्रूव्ड, इंजुरी इज आल्सो देयर। ऐसा भी नहीं है कि अगर ग्रीवियस इंजुरी नॉन वाइटल पार्ट में होगा तो 307 नहीं बनेगा, ठीक है? अगर किसी का आप नस काट दीजिए हाथ का, 307 बनेगा कि नहीं बनेगा?
अगर
बनेगा ना। इसीलिए वाइटल नॉन वाइटल सबसे से कोई मतलब नहीं है। यू फेस द ट्रायल और बाकी अपनी जगह। सुन लिया
मैडम, एक पॉइंट कंसीडर
हाँ,
किया जाए
सब पॉइंट कंसीडर कर
कि 307 अगर नहीं लगेगा तो
नहीं।
मजिस्ट्रेट ट्रायल हो जाएगा, तब मजिस्ट्रेट
नहीं, अभी 307 का हम क्वेश्चन नहीं कर सकते ना। क्रिमिनल रिविजन नंबर 1480 of 2023. Counsel for the parties are present. This petition has been filed for the following relief. The learned counsel for the petitioner submits that there is case and counter case between the parties, and the petitioners had filed the criminal case prior to that of the other party. He has further submitted that there is allegation of grievous injury on non-vital part of the body, that is in the hands. This fact is apparent from the submissions which was advanced by the counsel for the petitioner, and he has further submitted that no case under section 326 or 307 was made out, and therefore at best it is a case of under section 323
and 325,
and therefore it has to be tried by the magistrate. The learned counsel submits that the impugned order refusing to discharge the petitioners is perverse and calls for interference. The learned counsel appearing on behalf of the opposite party state has opposed the prayer and has submitted that the submissions advanced by the petitioners are not enough to exonerate the petitioners under section 326/307 of IPC. The fact remains that there was and I submitted that the impugned order does not call for any interference. The arguments of the petitioner are essentially matter of trial. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, it is not in dispute that there is case and counter case between the parties, and that by itself is not a ground to discharge the petitioners. Further, so far as the applicability of section 326 and 307 is concerned, this court is of the considered view that merely because the injury was in the although the injury report has not been filed by the petitioner in the present case, but even if the case of the argument of the petitioner is taken into consideration, merely because the injury was found on the grievous injury was shown on the hand, the same is not sufficient to hold that the case, no case under section 326/307 is made out. The narration in the FIR, upon perusal of the first information report, it is apparent that there are serious allegations and the injury is said to have been there in the and there is also a head injury said to have been there with respect to one of the victims. This court is of the considered view that the learned court has referred to the various paragraphs of the case diary and has also recorded that the petitioners had made assault and there are several victims. Having gone through the impugned order, this court finds no illegality or perversity calling for any interference in division jurisdiction. Accordingly, it is dismissed. Communicate. It is further observed that any observation made by this court will not prejudice the case of either party.
Supplementary list for final disclosure item 1 WPL 5266 of 2021.
Where is the domestic inquiry report?
It is at page 58 of the written petition.
Kindly read it. It's one page.
White letter number name dated 29/3/2017. I was appointed inquiry officer with regard to domestic inquiry against Mr. Shatrughan Karmali on his grave misconduct of willful absenteeism from duty without any information or permission with no concrete reason. I fixed date on 31/3/2017 for his presence and for securing his version on the said misconduct on his part. He did not present himself on applied date and time. The messenger through whom the letter was sent to him returned the letter and said that Mr. Karmali was absconding from his house for more than a month in connection with an incident of criminal nature. After that, I gave him an opportunity to place his version, write my letter number NIN dated 31/3/2017, but he could not present himself before me. Therefore, I took documentary evidence available in the record of the company, and I have no doubt that he was absent from 9/3/2017. There
It is the
is
finding in the inquiry report that the notice was served upon his wife.
there is no finding with this.
Rather, there is contrary finding with respect to the first notice.
The PN says that it was not served because he was absconding for more than 1 month. But his own written statement is that he returned on 22nd, and from 22nd he was visiting the factory, but he was prevented. And on 25th he also admits that his wife received the show cause notice. So if his own version is to be
At the
believed,
stage of this scrutiny of the domestic inquiry, the court will only have to examine the materials in the domestic inquiry and will not enter into the submissions of the rival parties with regard to one or the other state.
the inquiry report is brief. There is no drawing of the proceedings of each
Nothing is
date.
there.
There is a one-page inquiry that I admit.
The
But-
one-page inquiry, and rather whatever you are submitting that his wife received, and or maybe that he stated that his wife received. Wife is not even a witness, right? We do not know what happened. But your inquiry report on the face of it is reflecting that he was absconding and it was not served. This is what is reflecting in the inquiry report. Therefore, the proceeding was expired.
Proceeding was expired.
Now the question is that the proceeding being ex parte and there is no finding that notice was served upon him. So, what remedies were available with you? What kind of steps you could have taken?
The step could have been if his attendance had to be compelled, it could have been by giving paper publication, which has been mentioned in the award also, that it could have been published in a local newspaper if he was not coming.
See, the learned court has
And there is they could have sent it by speed post, which is
that
there in
has
the
also been
standing
recorded that it
which is in
should
the
go by
standing orders.
standing orders.
standing orders.
So the court has by and large scrutinized the material and has come to a finding. So your contention that based on the pleading some finding was to be recorded.
Not only pleading, the evidence is also the same. Evidence of Shatrughan Karmali can also be seen. The same contradictory stands,
No,
which will prove that he did not come with clean hands.
Considering the limited
Yes.
jurisdiction, we
No,
have
but
to
even
see.
if the jurisdictional error is that the workman does not come with clean hands, he makes false statements repeatedly in his evidence also and in his own WS also. If both are scrutinized, it would have become apparent that he had full knowledge of the show cause and he deliberately avoided the inquiry because he says I came back on 22nd. Even the evidence can be seen apart from the pleadings. Yesterday I referred to the pleadings. The evidence of Shatrughan Karmali is also there, paragraphs 5-6, in which he's again making these statements. When it comes to inquiry, he says I was out for more than a month. And then in his own next statement, he says, no, I was absent for only about 15 days.
That's
So
now you see.
therefore
So far
since he
as
is not approached with clean hands, on that ground at least we are saying he is not entitled to any relief of back wages because he has himself not approached the court with clean hands. He has made false statements, which is proven from the records, his own statements in the records. If the whole case is seen in the totality, the labor court could not have missed it, saying that I'll only see the inquiry and the PN says that PN wrote that and that is also with respect to only the proceedings of the inquiry. The show cause was served on him.
there was no adjudication with regard to legality and validity of inquiry.
It was not tried as a preliminary issue. but there is a finding. There is not even a direct issue. The issues have been framed in the award, but it has been straight away dealt with from paragraph 27 onwards regarding the enquiry. And then the labor court examines it on merit also. That what was the reason for his absence, and paragraph 41, in paragraph 41 it is the finding of the labor court. There are three clear findings. One, that his absence was unauthorized. In paragraph 41 the labor court also says it is also a case of no evidence, because the labor court admits in paragraph 41 that he has not given any evidence except that one vague statement that I was beaten up and I had to take refuge somewhere else. What was the case? What dispute? Nothing is there. The labor court also records it in paragraph 41, the last portion of the paragraph, that there is no evidence from his side, and that
Where
is
is that? Where is that finding?
that is page 92. The last about 5 lines. Although there is no evidence as to why the workman was not in position to come to industry to inform about happenings against him, and further there is no evidence on record as to how the workman was not in position to inform about his absence to industry for 25 days, but it is a matter of common experience that every human mind cannot think alike, and some people become more distracted even in the slightest trouble. So this is all presumptuous findings.
And you have also said that the workman has been working somewhere else.
Yes, that is in the supplementary evidence.
Since when is he working as per your records?
The RTI which we had given in the supplementary affidavit shows that he was working since 1st August 2019 at page 12. Date of coverage.
1st August 2019.
Yes, that is the date of coverage in Dilip Motors.
1/8/2019. Yes, have you been working since 1/8/2019 as per the records?
No, this
Because your
supplementary
PF
affidavit has been filed before this report. This,
No, that's
this
right.
was not part of the.
I just want to know from you, right? The order is payment of back wages till reinstatement.
Correct.
So this order has not been complied so far.
No,
Did you file any execution?
I'm not aware of that.
You should be aware of it. How do you say you are not aware of it? They have not filed any petition for stay. Did you file any petition for stay?
We filed the petition for stay of the 33C2 proceeding,
33C2.
and that was stayed
Okay. But
after he refused to
that's
accept
right.
the offer.
okay, 33C2
But no
is a
execution.
different thing.
Yeah.
33C2 is basically claiming the amount, right?
Yes.
And so far as execution is concerned, no execution case was filed
No, no.
as per the records. So do you want to say that even if a workman joins some other organization after the order passed by the award, right, he is entitled to back wages till he is reinstated?
No, but this RTI does not show that he had joined there. This is a date of coverage 1 August 2019. This is talking about the establishment.
Yes, certainly he is working in that establishment.
No, no, about the establishment status.
You have not.
That the office.
Yes, no. You have shown us on the last date. What is
Yes.
it? You place this for his
It
benefit.
is the RTI reply annexure 9 starts at page 9. The question where a copy of list of establishments, last question right side they are giving the reply. A copy of the list of establishments obtained from establishment search from EPFO website so and so is enclosed, wherein the name, address and EPF code number of the establishment is available. This is in reply to the question. Please provide full particulars including name, address, employer code of the organization, establishment where Shatrughan Karmali was employed, and the period of such employment. So
But
this
where
is
is
the
this?
annexure
Where is the
provided.
answer?
This is the RTI reply by the EPFO, and they have given in the annexure the name of the employer.
The name of the employer has been given. Where is the date of duration of the employment?
The coverage is 1st August 19. So on 1st August 19, he was covered under this organization.
There is showing about the establishment status.
And moreover, there is no denial also.
Date of setup of establishment 7th January 2019. Last updated on 7th September 2019. Establishment details, establishment status, date of exemption status, unexempted, pension and so and so. Working status, live establishment, coverage section, so and so. Actionable status, actionable establishment, date of coverage 1 August 2019. This is not showing the status of that the workman is working.
That is the status of the company.
They have not denied, they have not filed a counter affidavit to this saying denying that I have never worked in Telemotors, because that is in reply to the question, provide the list of the employers. And instead of giving the direct reply, in the RTI reply, they just give the annexure from the website.
And this RTI has been filed on 35/2022.
That's right. You have not responded to this. Now you tell us what is the answer to this finding which has been recorded by the learned labor court, and how still you will be entitled for back wages.
Which finding in addition?
The finding that has been placed by him.
Paragraph 41.
Yes,
May I read the whole paragraph?
you can read
It will be clear.
that would be
The
better.
case of the workman is that he had left his house due to family dispute and was away from his house. Although the workman has not filed any documentary proof of alleged family dispute and assault, that is registration of any FIR, complaint to any authority, local panchayati, medical prescription or injury report, etc. But he has adduced oral evidences on this point. In paragraph 4 of his affidavit, the workman has deposed that on 9/3/2017 he was assaulted due to family dispute, and to save himself, he had left home and gone out of the city. For that reason, he could not inform to the management. The management did not cross-examine to witness on these points. During cross-examination of the workman, the management has not even suggested to the witness that there was no dispute in his family and he was not assaulted and was present in his house. And further, there is no suggestion to the witness that he has absented himself intentionally and without any justified reasons. Therefore, a conclusion. Reasons of absence which the workman has stated in his examination in chief is uncontroverted and undisputed by the management during cross-examination of the witness. I further find that the inquiry officer in his inquiry report also has mentioned that the messenger through whom letter was sent returned the letter and said that Mr. Karmali was absconding from his home for more than a month in connection with an incident of criminal nature. Thus, from inquiry report, also evidence of the workman gets corroboration that there was some incident of criminal nature with the workman and he had left house due to said dispute. Therefore, case of workman that he had left home due to some dispute is proved and established by oral evidences of the workman as well as from other materials available in the case record. The workman Shatrughan Karmali has further deposed that the management has sent a letter on 22/3/17 and called his explanation, but he could not submit reply because he was out of the city. During cross-examination in paragraph 15, this witness has admitted that he had not gone for work in the company for 2 months because he had left home due to land dispute. Exhibit 3 is a petition submitted by the workman before Honorable Member of Parliament Ranchi on 6/8/2017. The workman has mentioned in this petition that he had left home due to assault and family dispute and he could not inform to the factory for 2 months, and in the meantime he was terminated from service.
That's
The workman in Exhibit 3 has mentioned that he got information about his termination after returning home. Therefore, from Exhibit 3, it can be inferred easily that the workman had returned home after passing of the termination order dated 3/4/2017. Under these circumstances, it is well proved that the workman had left home due to some incident of the criminal nature and he returned from home after passing of the termination order. Thus, the workman has been able to prove that the cause of his absence was family dispute.
just okay, fine. So some family dispute has been proved through oral evidences. Maybe that there was no documentary evidence to that effect, and there was no cross-examination of the workman at this point. How do you, what do you have to say so far as the your stand which has been taken that you were coming to the, you had come to the organization on a particular date, your specific stand in your written statement,
Your leadership,
page
that
number
is-
27.
Your leadership, this is a question of fact.
It is a question of fact, but still, that is your specific case.
Your leadership, which point?
Para number 6.
Six.
6 is the
5,
workman
6.
returned on 21/3/2018.
Yes. So it is his own, and again in the evidence also at
And
page
since
60.
22/3.
When did you return?
And his
When did you return?
No.
The date, your absence is for the period from?
That is from 9/3/17 to 22/3/17.
9/3/17 to 22/3/17, right? So this date is 2018 or 2017?
This should have been 17. At 6.
Yes.
That the workman returned Ranchi on 21/3/18. This
Yes. It is 2017 or 2018? It is
this could have been
2018.
verified only through cross-examination and examination.
No,
from the
what is your examination in chief? Let us know.
annexure 5, page 60.
Page?
60. That has 4, 5, and 6.
Anna, 4, 5, and
4,
6.
5, 6, same lines. But
Yeah,
here the
कि
date
मैं-
is correct.
हाँ, यह कि मैं 22/3/17 से नियमित रूप से प्रबंधन के यहाँ सेवा योगदान के लिए जाता रहा, पर प्रबंधन के द्वारा मुझे कार्य नहीं करने दिया गया.
But the finding is that you were away for 2 months.
That is he is saying. But in the domestic inquiry, the charge against him that he was absent from 9/3/17 to 22/3/17, on the basis of which termination letter has been passed.
The finding is that the workman had returned home after passing of the termination order dated 3/4/2017. And here you say that on 22/3/2017 you came back and you were attending, you were going to them, but you were not permitted to join.
Leadership.
Mr. Bakshi, it is very difficult to scrutinize the evidences to such an extent under 226. We will not do so. Anything, whatever you have to say on this aspect of the matter regarding back wages, you can make your submission.
In addition on the back wages point,
On
I
back
have
wages.
a judgment.
Yes, that in plate, that irrespective of the fact that there is no abovement, 50% back
Although
wages.
there is amendments made by the workman.
You have
Defined.
referred to certain abovements.
Correct.
Right. So,
the-
what do you have to say so far as your this employment post award is concerned? It can certainly be verified
it can be verified.
under section 33 C2 and in that proceedings also.
You already said.
And if you are found to be employed somewhere and
Then
then
for that period it may not be paid.
for that period it may not be
You
paid.
know.
That can be observed. If you are absolutely correct in saying, that will be subject to evidence at the stage of 33 C2. Because any person who is having an order of reinstatement does not file any execution case also, right? Which shows that he has not shown his willingness to join. Then under such circumstances, what kind of back wages can be given to him till his reinstatement, particularly when they are saying that you are already employed somewhere. So, if he is ultimately found that he was employed somewhere, because this PF code will certainly show many things. That should be clinching, isn't it?
The PF records cannot be disbelieved.
That cannot be disbelieved.
Because
So those are absolutely undisputed records, would be undisputed records. If you are able to show anything, even in the proceeding under section 33 C2, we'll just observe that if you are able to show this before in the proceeding under section 33 C2, then he will be entitled to back wages only till that period. Not beyond that. That much of relief can be granted or whatever. I think for that you should not be having any objection, because you cannot work at two places simultaneously. And that recovery is also pending. So the quantum of amount and the period of amount, both will be adjudicated under section 33 C2, isn't it?
Yeah.
That's it. Okay, WPL number 5266 of 2021. Heard the learned counsel for the parties. This writ petition has been filed challenging the award dated 4th October 2021 passed by learned presiding officer Labour Court Ranchi in reference case number 50 of 2018. Thereby the order of dismissal of the respondent and directing reinstatement with 50% back wages is under challenge. The learned counsel for the petitioner submits the terms of reference was as follows. कोट करना है इन्होंने written submissions दिया तो उन्होंने इसी में. The terms of reference was as follows. The learned counsel for the petitioner has submitted that the legality and validity of the domestic inquiry was not taken up as a preliminary issue, but while deciding the case, this fact has been taken into consideration, and a finding has been recorded by the learned court in that connection in paragraph 25.
Paragraph 34 and 35 is the finding that the domestic inquiry is not proper.
Para 34 and 35 of the domestic inquiry of the impugned award, that the domestic inquiry was not fair and proper.
Thereafter, the Labour Court has
Thereafter, the learned Labour Court, the learned counsel submits that the said finding is perverse inasmuch as the workman had taken a specific plea that the notice was, in the written statement, that the notice was served upon his wife and he could not file the response to the show cause issued by the management on account of unauthorized absence. And therefore, the entire proceeding was within his knowledge. The learned counsel has submitted that the workman, having avoided to respond to the show cause, cannot take advantage of this fact, and therefore it cannot be said that the inquiry was not fair. The learned counsel has also placed the inquiry report. It was exhibited before the learned court, and the same is contained at page number?
Page 58.
Page 58.
Exhibit L.
Page 58, within bracket exhibit L. The learned counsel has submitted that the workman had taken conflicting stand in his written statement, and the fact that the absence was unauthorized is not in dispute. Therefore, the grant of back wages is also not sustainable in the eyes of law. 50% back wages. The learned counsel further submits that a supplementary affidavit has been filed in the present case indicating that the workman had taken up another employment with effect from 1/8/2019, and in such circumstances, back wages till his order of reinstatement calls for interference, as the back wages may not be awarded beyond the period from 1/8/2019. Right? The learned counsel has further submitted that the workman never filed any petition for execution of the award. Rather, he had simply filed a petition under section 33(c)(2) for computation of the amount payable arising out of the impugned award, and the said proceedings are pending, and an interim order with regard to the said proceedings has been passed by this court. The learned counsel submits that the workman has not responded to the supplementary affidavit which has been filed by the petitioner with regard to the engagement of the workman in a different establishment since 1/8/2019. The learned counsel has submitted that the impugned award is perverse and calls for interference. The learned counsel, appearing on behalf of the opposite party, has opposed the prayer and has submitted that even though the absence from duty is admitted, but the workman had sufficient reason for his absence, and in view of the fact that criminal case was lodged and there was family dispute, due to which the workman was away from his home. He submits that even in the inquiry report it has come that the notice could not be served upon the workman as the workman was absconding.
And there's a finding to that effect also in paragraph 44.
He has referred to the finding of the learned court in paragraph number 44 of the impugned award. The learned counsel submits that the scope of that the learned court has considered the materials on record and there is no scope for reappreciation of materials and there is no perversity in the impugned award. He has relied upon the judgment passed by Honorable Supreme Court in the case of आपका था ना submission.
Written notes
Yes, it is there.
1986 4 SCC
Huh.
447.
In the case of in the case reported in bracket
CSR.
1984 bracket close 4 SCC 447 paragraph 17 and bracket 2014 bracket close 4 SCC 270. With respect to the employment of the petitioner in other organization, with effect from 1/8/2019, the learned counsel for the workman has submitted that the material that although no counter affidavit has been filed to the said supplementary affidavit, but from the perusal of the supplementary affidavit also it is not clear that the workman was working in any other establishment. They have submitted that 1/8/2019 is the date of establishment, date of coverage of one establishment, but that by itself is not sufficient to show that the respondent was one amongst the workmen working in the establishment.
The details
In the
are
other
the
establishment.
details of the establishment.
Sorry,
Not-
the details are with regard to the details of the establishment and not with regard to the details of the respondent workman. However, he has submitted that the proceeding under section 33(c)(2) is pending, in which the period for which the workman would be entitled will also be is also under consideration. If the workman had joined any other organization after passing of the award, then such evidence can be placed before the court in proceeding under section 33(c)(2) and appropriate order can be passed. But so far as the present case is concerned, no such order be passed with regard to the period post
Employment.
impugned award. That's it. He submits that the adjudication in the present case be confined to the legality and validity of the impugned award. That's it.
The implement.
Okay.
Yes.
After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that the petitioner themselves had relied upon the inquiry report dated 3/4/2017, which was exhibited before the learned court. The inquiry report reads as follows. एक पन्ना की order quote कर देंगे, page 58 में. This court further finds that both the parties had appeared before the learned court and have adduced their respective evidence. And have filed their written statement and have adduced evidence, both oral and documentary. The case of the management, the case of the workman was as follows, para number 3 and para number 4. And that of management was as follows. ठीक है? Para 4 है case of management and para 3 है case of workman. On the basis of the pleadings of the parties, the following issues were framed. Para number 7. On behalf of the workmen, 2 witnesses were examined, including the workman, and altogether 5 exhibits, 5 documents were exhibited. Including the initial date of, including the appointment letter dated 4/12/2006 within bracket exhibit 1. And then 22/3/2017 the show cause issued to the workman, and 3/4/2017 the termination letter. The management examined 2 witnesses and produced the certified standing order as exhibit 1 and copy of show cause notice dated 22/3/2017 said to be served upon the wife of the workman which has signature dated 25/3/2017. Then, which was exhibit B, notice dated 29/3/2017, asking the workman to appear on 31/3/2017, exhibit C, and copy of notice dated 31/3/2017 issued to the workman by the inquiry officer directing the workman to make contact within 2 days for deciding further course of action, exhibit D. And also the letter of termination dated 3/4/2017 within bracket exhibit G. Apart from the other documents, the inquiry report has been exhibited as exhibit L. Another letter dated 5/4/2017 regarding termination of the workman has been filed as exhibit M. The learned court considered the materials on record and disposed of the issue number 1 white paragraph the learned court considered the materials on record and Sorry?
Paragraph 44.
Yes. Prior to that. And in paragraph and recorded findings in para 24 as follows. 24 का finding लिखिए. In paragraph 25, the learned court considered the second point as to whether the inquiry formulated the second point as to whether the principles of natural justice were followed in the domestic inquiry and as to whether the action of the management was fair, reasonable and just. The learned court ultimately recorded the findings in paragraph 26 and 27 by observing in paragraph 26 that para 26 is not required actually. Para 27 as follows, and ultimately after further considering the materials recorded finding in para number 44.
44. After holding that.
Para number 41 as follows. Para 41 is important. Para number 41 as follows. Para number 41 and para number 44. Upon perusal of the findings recorded in para number 41, this court finds that the workman had adduced evidence with regard to his reasons for absence from duty. Although no documentary evidence as such was filed, but the management did not cross-examine the workman on many points as indicated in para 41, and consequently the evidence of the workman with regard to his reasons for absence from duty remained uncontroverted.
Oral evidences.
Yes, oral evidence is right. The learned court ultimately held in para 44 that termination of the workman on the ground of remaining absent for 27 days was not justified. And it was not a case of habitual absenteeism. Having recorded the aforesaid finding, the learned court has considered the relief which could be granted to the workman in terms of provisions of section 11 capital A of Industrial Disputes Act. and ultimately recorded in paragraph 49, and ultimately held that the workman be entitled for 50% of the total back wages. The learned court also the learned court also observed that the workman had failed to bring convincing evidence that he was not gainfully employed anywhere during the relevant period. This court finds that the learned court, while awarding 50% back wages, has relied upon the judgment passed by this court in the case of Tinplate Company of India versus TVR Raju, reported in 2021 within bracket 1 bracket 2 JNDR 176. Whose relevant portion has been quoted in paragraph 48 of the impugned award. This court finds that the award is a well-reasoned award and has been passed after discussing the materials produced on record. The inquiry report itself so far as the inconsistent stand which has been taken by the workman is concerned, the same was essentially a matter of evidence before the learned court, and there is no scope for reappreciating the materials and coming to a different conclusion unless the award is perverse. In view of the scope of interference in the writ jurisdiction against the award, in the light of the judgment cited by the learned counsel appearing on behalf of the respondents, this court finds no perversity or illegality in the impugned award. The impugned award is dated 14/10/2021 and the evidence of the पहले का पीरियड कैसे कंसिडर होगा 1919 के बाद का पीरियड नहीं.
From the date of dismissal till his reinstatement, that is not.
The award indicates that the 50% back wages is to be given from the date of termination/dismissal till his reinstatement. Admittedly, the workman has not been reinstated so far, and it is sufficient to observe that if the petitioner is able to prove in the proceeding under section 33C2 regarding engagement of the petitioner post 4/10/2021. Right? Yes, sir.
That won't be the jurisdiction of the court under 33C2.
That would be the jurisdiction. Post
It has
4/10/2021
Under 33C2, it has only to compute the amount.
as in terms of the award till the
Yes.
state of reinstatement.
Yeah, right.
But if he is engaged, if he is otherwise engaged, then what will happen after the award?
That had to be, that material, all those evidences had to be produced before the labor. Now they are bringing up.
That is always open in 33C2 when the award says it is still reinstatement. When reinstatement itself is an uncertain and not a fixed event, whether he has come to join or whether the management has prohibited, it is seen in every 33C2 proceeding what steps were taken for joining.
The factual aspect as to whether the workman was ready and willing to join after the award, and that as to whether the workman was employed elsewhere even after the award dated 4/10/2021 is essentially a matter of evidence which has to be considered in the proceeding under section 33C2 and not in the present proceedings. It is suffice to it is suffice to observe that the aforesaid aspect with regard to the employment of the petitioner and his willingness to join post 4/10/2022 will be considered in the proceeding under section 33C2. And so far as the present award is concerned, this court finds no illegality or perversity. This petition is dismissed with the aforesaid observation. Your witness has come. Where is the counsel for the other side? Where is the counsel for the other side?
Item 2 from plaintiff PS1 of 17.
In this case, Your Lordship, we have prepared a IA. For the self-same matter, Your Lordship, a title suit is pending at Lohardaga. A partition suit between the same parties and for the same set of lands. So, with a order of the Honorable Supreme Court, Your Lordship, we have drafted this IA. It is all complete, Your Lordship. I was only praying that this IA may be looked into and thereafter.
See, in the state of in testamentary suit, we will only see the legality and validity of the will and nothing more.
Yes, Your Lordship.
That
Only
is
to
it.
that extent
Then
we
how
have.
the partition suit has any bearing in this matter?
Because, Your Lordship, for the same thing.
Maybe same thing. You see, partition suit is ultimately, suppose somebody has passed on a property through a will, then whatever be his share, ultimately which comes up in the partition suit, it will devolve upon him.
That property, Your Lordship, which is in the will, that is also in that
Maybe
in that partition
it will be there.
suit.
Certainly, it will be there because it's a family property. Suppose Mr. Tiwari, suppose a property belongs to Mr. X, or it is the ancestral property, right? If he does not have a title, suppose a person executes a will without having a title on the property. We don't decide the title. We only decide the will. If ultimately it comes in the title suit that he never had the title over the property, the matter ends.
Your Lordship, by this IA, we have only prayed before this Honorable Court that the records of that original case, Your Lordship, that may be called for.
Not required.
And
Not
that
required.
is That is the
You
pronounced.
see, we are in the midst of cross-examination.
No, that is there,
Right?
Your
So
Lordship.
first let the cross-examination be over, we will consider your IA. I will just consider it, I am not inclined, I will dismiss it right away, no counter is also required.
Your
They are
Lordship,
not filing counter because for something what they are praying is legally not permissible.
Your Lordship,
So in the bill, we will only decide the
That's
legality
my
and
only-
validity. If suppose there is a bill, and under that bill, Mr. X says that the Ranchi railway station will pass on to Mr. Such and such, right? And all the witnesses are there and everything is there. The will is held to be valid. That will not pass on the property unless that person has the title over the property. Whether that person has the title over the property and to what extent he has the title over the property, that could be a matter of subject matter of partition suit. We are not deciding the partition suit. So we are not concerned with the title over the property as to who would get what share. We are only concerned with the legality and validity of it. And that
only
is
Your
all.
Lordship, we have prayed that the records of that suit may also be called for because the pronouncement of the Honorable Supreme Court is to that effect.
Which
That-
pronouncement?
Yes, Your Lordship.
You were not aware of this order when he was supposed to be cross-examined. On the last date, you were not there. With the consent of the parties, the matter has proceeded. With the consent of the parties, the matter has proceeded. Is it
we are
something
not
which you have
against-
come?
We are not against that he should not give his
No,
evidence.
we are
only saying, Your Lordship,
we
that
have proceeded with an understanding that you had only filed a petition for cross-examination, right? And the two evidences on affidavit has been filed. It has also been recorded on the last proceedings that one after another the witnesses will be produced and they will be cross-examined. Now it is in the midst of cross-examination. On that day I was not inclined to adjourn this case. Just ask him. I was not inclined. Why should a witness be discharged in the midst of the proceedings? Unless the court is not if the court time is